In a significant legal victory, President Bola Tinubu's electoral triumph in the February 25th polls have been upheld by the Presidential Election Petition Court. The court dismissed 3 petitions challenging his victory, one by former Vice President Atiku Abubakar of the People's Democratic Party, another by the Labour Party's presidential candidate Peter Obi, and the third by the Allied People's Movement. Now, these petitions were deemed to lack merit. However, both the Labour Party and the People's Democratic Party have expressed their intentions to appeal the judgment. President Tinubu's win remains unchallenged.
Atiku Abubakar of the People's Democratic Party and Peter Obi of the Labour Party, 2 men with a chance to pull an upset, had approached the Presidential Election Petition Court seeking to cancel the results of the election and have a rerun, citing a number of grounds. But in Judgment Day, there were the notable absentees in the courtroom, which had in attendance party chieftains including Vice President Kashim Shettima, who were present to witness proceedings. Substantial non-compliance with the Electoral Act, alleged corrupt practices, and overvoting certificate forgery allegations against Tinubu is forfeiture of $460,000 over alleged drug case and dual citizenship, the aspect of his not securing 25% of votes in the FCT, among other grounds that both men sought to nullify Tinubu's electoral victory. In its judgment, the court stated that Atiku and Obi failed to discharge the burden of proof by failing to state the specific polling units where electoral irregularities and overvoting, including multiple thumb printing, occurred. The court stated that the electoral body, INEC, isn't under any legal compulsion to collate results by electronic means as such, falls within its discretionary powers. It also stated that Atiku and Obi failed to prove their allegations of certificate forgery, while stating that the case of alleged forfeiture in a drug case was a civil case, one which Tinubu was never prosecuted, convicted, or sentenced. In dismissing the case on 25% votes in the FCT, the court maintained that the FCT is like one of the 36 states of the Federation without any special status. On those grounds, the court dismissed the petitions for lacking in merits. The court had earlier dismissed the petition of Allied People's Movement, which was hinged on the multiple nomination against Kashim Shettima. With this leg of litigation now over, the petitioners are yet to decide whether they would head to the Supreme Court or not. But the Labour Party has, in a preliminary statement, condemned the outcome of the judgment, saying that its lawyers are reviewing the situation on the next steps to take. Meanwhile, President Bola Tinubu has welcomed the judgment of the tribunal, in quote, with an intense sense of solemn responsibility and preparedness to serve all Nigerians, irrespective of all diverse political persuasions, faith, and tribal identities. President Tinubu, in a statement, urged, in quote, valiant challengers to inspire their supporters in the trust that the spirit of patriotism will now and forever be elevated above partisan considerations, manifesting into support for a government to improve the livelihood of all Nigerians. End of.
President Bola Tinubu has formally reacted to the Election Petition Tribunal's judgment that upheld his election. The president, who is away in New Delhi, India, to attend the G20 summit, is assuring Nigerians that it will work for the progress of the country.
Let me first of all apologize. It was a night of great expectations yesterday, and I did want to both learn and equally waiting anxiously to see if my job is one way secured or not.
We have Adeyinka Olumide Fusika, a senior advocate of Nigeria. Thank you once again for joining us this afternoon.
Thank you for inviting me.
All right. As this tribunal has come to a close, there have been a lot of discussions, particularly about BVAS. Now, the explanation was given that its use was discretionary within this particular ruling. And I know a lot of Nigerians are wondering, does this not defeat the purpose of having elections that are free from human tampering or human manipulation, glitch or no glitch? Going forward, what kind of wording and which document does it need to be presented in order to make sure that electronic submission of this data is sacrosanct and not left to the discernment of a human being, humans seeing as we are all fallible?
Well, let me start by saying that there's nothing, going by previous decisions of our courts on this issue of BVAS, the decision just rendered by the Presidential Election Petition Tribunal is very consistent with that. And in commenting, I am a bit constrained because we've been told that some of the parties will be appealing the decision to the Supreme Court. That being the case, one has to be a bit careful in making comments on it so that one does not prejudice or prejudge whatever the outcome of the appeal will be. But just for me, talking as a social commentator, I think that the confusion here, the problem here, which has got the credibility, seeming credibility of the election, is simply because the umpire in this case was, the Independent National Electoral Commission was quite loud and clear in the period, to the election that this was going to be used. As a matter of fact, they did trials in some states by elections, and they are sure that this will be done. But the court has said before now that the means and mode, the procedure for collating and transmitting the election to the head office of INEC, they have a discretion as to how this can be done. In the exercise of that discretion, they made Nigerians believe that it will be done by electronic means, that is BVAS and all the other whatever. And the blame here is not can be on the court. When a person makes a rule, like if two people are contesting and there's an umpire, and the umpire makes both sides to believe that this is the way this thing will go, I think it behoves the umpire to comply, to follow the rules that it has laid for itself. I think that is where the problem is here. Maybe it will be helpful. This is what I mean. We don't run a monarchical system of government where you make a law and then you say you are exempted from the law. You expect every other person to comply with that law, but you yourself, the maker of the law, you think that you should not comply. You are not exempted from complying with the law. In some of these, in the rules that INEC gave, if a political party fails to comply with any aspect of the rule, INEC will not, will bring the sanction down on those people. But in this instance now, we have a situation where it is INEC itself that has not completely complied with the procedure it has set out, laid out before the election. So for that reason, I think that INEC shares a big part of the blame. But as to the pronouncement of the court, like I said, given previous decisions of the court on the same issue, I believe that it is consistent. That's without prejudice to what the Supreme Court might eventually say on the matter.
But what about the tribunal's ruling regarding the 25% votes in the FCT? The tribunal made it clear that Abuja does not have any special status as has been erroneously believed. Is that also consistent with the position of the law?
Well, the law is what the court says it is. If it's not what, as a lawyer, I can only go to court to argue that please interpret this section of the law this way. my opponent will come and say, interpret it this other way, and then the court will make a pronouncement. Once the court makes a pronouncement on it, that this is it, the only option now is for the aggrieved party to go on appeal to a higher court, which will also look at the decision. But I think I was about the first, when Mr. Gbakuba, very senior lawyer in this country, even before the election, wrote a letter to INEC to clarify this point. I think I had the opportunity, I was asked in an interview with your station to comment, to react to that letter, and I made my own understanding of the issues very clear. I initially thought that it was a non-issue, something that should be like a joke. It seemed to me like a joke that that kind of position was being canvassed. But subsequently, a lot of senior lawyers came into it, and given the fervency with which they were arguing it and all that, I again went back to look at the provision of that section of the Constitution again. And if I may express my personal opinion again, without wanting to prejudge whatever the outcome of the case would be at the Supreme Court, there are two key things that we should be looking at here. The first one is that Nigeria is a republic. A basic tenet of republicanism is that all citizens are equal. When you proceed from that base, in other words, there is no inferior citizen, there is no super citizen. There is no citizen that is superior or inferior to any other citizen of Nigeria by reason of religion, race, profession, ethnic background, and those other things. So we are equal in our citizenry. We are bound by the law. The second point is we also say we are a democracy. And in a democracy, it's one man, one vote. It is not one ethnic group, one vote. It is not one religion, one vote. It is not one state, one vote. The kind of, in our presidential election, every citizen has a right to cast his vote. Now, there's a reason for the provision of the Constitution relating to spread. If you look at it very well, it's actually possible for a section, for a candidate to have majority of votes from a particular section of the country without having any presence in other sections of the country. This was the bane of the first republic, and when the military came in, they thought that they can foist, bring us together more. So the history of this thing started with this 25% started in 1979. And the logic is very simple, that for you to be president of Nigeria, it also applies to some extent to states, but we are talking of the presidency now. For you to be president of Nigeria, you must be accepted. You must be shown to be accepted, to, a reasonable extent across, the length and breadth of Nigeria. And the length and breadth, then the test was then put there that, okay, you should have at least 20, your majority, even if you are saying you are the majority, the person that had majority votes in the election, you must have at least a quarter of the vote, in other words, 25% across 2/3 of the states of the Federation. We didn't have FCT in Abuja, or FCT, or Federal Capital. Lagos used to be the Federal Capital, and it was also a state in 1979, and also, I believe, in 1983. It was also a state. So this problem of that we are facing now didn't arise. But even as the capital of the Federation in 1979, Lagos State was just one of the 19 states at the time. So that time it was 2/3 of 19 states. Now, if you say we now have 36 states, you say 2/3 of 36 states, the Constitution made the same provision. But then there is what we now call Federal Capital Territory, which is not a state, But you have citizens of Nigeria also living in that area. If the essence of this provision of the Constitution is so that Nigerian citizens, who are also equal in their right to other citizens of Nigeria, living in Abuja, are also reckoned with in determining whether a person has a spread. That's my own understanding. So you now take 36. We are now talking of 30. Each state is a unit. FCT is also a unit. So when it says 36 states and Abuja, what is basically telling us, well, in my own understanding of constitutional law, I may be wrong, is that we are talking of 2/3 of 37 units. Each state being a unit, and Abuja, the Federal Capital Territory, being the 37th unit. So in other words, when you are talking of 2/3 of that has to be met, of course 2/3 of 36 will be 24, if my arithmetic is good enough. But when you add Abuja to it, it means that the person must have, when you add Abuja to it, it becomes 37. It then means that the winner must have 2/3 in 25, across 25 states of the federation, not specifically Abuja. It becomes a unit of whatever. And the reason why I think Nigerians should understand that the logic of this is, if the argument being canvassed to the contrary is correct, what it would then mean that, say for instance, a presidential candidate wins not even 25% or 50% or whatever, he wins, I know it is not possible, but it's just for argument's sake, he wins 100% of all the vote cast in 36 states of the federation and then scores 0 in Abuja. The argument here is that that person cannot be declared president because the people, Nigerians living within the enclave called the Federal Capital Territory, are now super citizens. You know, they have a veto on who becomes Nigeria president. So if the person wins 100% in 36 states but scores 0 in Abuja, then it means that that person is not qualified to be president. It's so illogical. In my view, it's an illogical. It's like creating Lagos State, Sokoto State, any of the other states. They are not super states. They are all equal in their rights in determining these 2/3. So how can, and in a federation, don't forget that we're also running a federation. A federation, in a federation, it is the states that come together, not local government, not a capital territory, so to say. The Federation of Nigeria is made up of states. So if you are having a federation, if anybody is a super component of that federation, it will be the states, not a local government, which in my honest opinion, that's what a glorified local government, that's what the FCT is. So that is what can be a super state. But again, like I said, there's no super states in Nigeria. The people in Sokoto have no greater say in who becomes president of Nigeria than the people living in Lagos State. The citizens of Nigeria who are residents in Sokoto State have no greater say than the citizens of Nigeria living in Lagos State. In other words, we don't have super citizens in Nigeria. So for somebody to say, once you live in Abuja, you have a veto, you can exercise a veto on who becomes the president of Nigeria. Well, in my own understanding of constitutional law, of the basic principles of federalism, of republicanism, of democracy, that argument to me, it can't hold. It doesn't hold water. But again, like I said, the law is what the court says it is. The Supreme Court may come forth and say, well, all these things I'm saying is rubbish. I mean, it's something else. But that's my own understanding of it.
Right.
It will be illogical. It doesn't make sense at all.
Well, whatever they say, thank you for giving us that very layman's term example of exactly how those dynamics play out. I'm sure a lot of people would have appreciated how straightforward that example was. Thank you so much for joining us this afternoon. Adeyinka, Olumide, Fusika, thanks for joining us on Newsday.